around contract law in 40 slides. So what I wanted to do is remind you that you have a whole lot of resources already, and for you to be thinking about how you're going to pull your resources together for an open book exam. And so what I've done is I've taken what was initially 40 slides, I think there are 42 by the time I finished, from across the slide packs that we've had, which for me are kind of diagrams showing the high level stuff. Then the other thing that I have created for you, which should be available now, and I'm a little worried it's just going to freak you all out. It's not meant to freak you all out, but I will show you right now, is this mind map, which you should be able to find. Now, basically, when you're in the, so this is the face-to-face class, but the OUA one looks very similar. I just think because of the way that Canvas works and because I didn't have it open, I think that the name of this is slightly different in the OUA one because I had to type it manually. But you'll be able to work it out. It's in Module 12, the Week 12, Topic 12 area, and there's this button will let you open this mind map. Now, use this if it's helpful to you. If it overwhelms you and makes you stressed, ignore it because it's just effectively my notes. So, broken down though, instead of into the topics, into these three areas. Has a contract been formed? Now, I don't think it'll be any surprise to you that the questions on the exam are really similar to the questions that you've had in your assignments so far. Sorry, excuse me sitting, it's just easier to drive. And ultimately they go to whether or not a contract has been formed or not. That is actually what this subject is all about. It's called Fundamentals of Contract Law, but it's really about making contracts. And Advanced Contract Law is really about ending contracts, how they come to a conclusion or how you terminate them or how they're breached and what that means. So basically what happens in here is that you can hit these little buttons or you could just go through with a little arrow here and it will take you in each case to whatever is in there. Now, it's a bit clumsy. I'm a much better lecturer than I am a website designer, right? So, basically, in each of these topics, it will take you to the pictures. Now, this is a bit ugly on that screen, but depending on where you're looking at it. So, you can navigate it however you want to. A number of the cases will be linked out to the cases as well, if you find that useful. I haven't done it yet, but I will also produce this as one big, ugly Word or PDF document. I think it has to come out as a PDF document for those of you who like linear things. But basically, it's just a compilation of all of the materials that you have, which I just keep updating as the cases, I become aware of them. So it will include cases here that we haven't spoken about because they haven't been important in the classes. Or they just, the conversation just hasn't got there. It will include ones that we have spoken about and there'll be no links. So because I only link them when they're easy, this is it started off life for my use, not for yours, but I've shared it the last few semesters because some people have found it useful. The most useful thing about it, I suspect, is this button here. So I know clearly you can't take this into an exam with you, but if, for example, you decided that I need to think a little bit more objectively about what? Capacity. I've got capacity in my head at the moment. It'll just bring up everywhere that capacity has been highlighted. And you can move through them and see what's in there. Or whatever other word there is, okay? So play with it to your heart's content. If you think you can add to it, send me stuff and I'll throw it in there as well. And I'll turn it into the Word document for you as well. But all care, well, plenty of responsibility, but if it's useful to you, use it. If it sits there and it overwhelms you because it's a big messy mind map, then yeah, I suggest that you leave it alone. The way that it's structured too goes around these questions. I'll just reduce it back to, just restart back to the beginning. Has a contract been formed? Once, if our answer to that question is yes, then we can move on to what are the contents of that contract. And then thirdly, some ideas around thinking about thought leadership and critical thinking. There's very little in that section because I haven't necessarily linked it through. Okay, so that's there for you to play with to your heart's content. Let's go back to the slides, and don't worry, I won't read all of them, and I will fly through. So ultimately, contract problems tend to fit in two categories: the problems for the fighters and the problems for the lovers. So with the fighting, the problematic scenario questions, we're really asking the question usually, is there a contract or not? You're not getting yourself caught up in what quantum of breach is or whether there's a right to terminate. Beyond perhaps the question, well, so we do know one thing about termination, don't we? What do we know about termination with a contract? We only did it in the last couple of weeks, and we did it in the context of classifying contract terms. So what kind of terms, when breached, allow the person suffering from the breach to call termination? Sounds like call. Sorry? So if there's an essential term. So when I say you don't know anything about termination, you do know some things about termination, and they may be relevant in the exam, so think about it that way. So if you are actually, but if the question came to you, in this scenario, could we terminate? It is very likely that what you have to do is work out, is there a contract at all? If there is a contract, does the complained of action, is that a term of the contract? And if it is a term of the contract, or so if the broken promise is in fact a term of the contract, is it an essential term? Now you might not be able to answer all of those questions, but you should be able to get part way down the track at least. I've spent most of my life on the lover's side of the equation here, trying to work out what should be in a contract. And you've done a bit of practice with that in your second assignment now. You've drawn on a fact scenario to think about what kind of promises the parties need to make each other or should have made each other that you would include in the written document. You might have even thought about whether which of those things would be essential terms and which ones would just be simply warranties. You might have actually thought about whether something was in a non-imminent term or an intermediate term or not, but usually you would want to be quite precise about that and not leave it to a court to chance. And in fact, one of the reasons that you might have pointed out along the way that we would want to have this written down and perhaps linked to the termination clause is we want to be able to walk away if that, if this doesn't happen or if that does happen. And you're also thinking about the kind of things that you might need to do to mitigate risks. So again, it is not unheard of that a scenario in the exam might ask you to do a rough and ready list of the kind of terms that you might might recommend be put into a contract. The look on your face there was quite surprising.
Yeah, so boilerplate clauses and stuff like that.
Not necessarily a boilerplate clause, but it might ask you, well, what would you put in the contract?
Yeah.
Given the scenario that you've got, what's been left out, or what would you include in there?
Okay. The reason my eyebrows went up is I was imagining having to go through that encyclopedia of forms.
No. And the thing is, the Encyclopedia of Forms and Precedents there was to help you in that scenario.
Yeah.
You are not, please do not be printing out the Encyclopedia of Forms and Precedents, taking it in with you, right? Okay, I don't want anybody to have a hernia on my watch. It's not going to be useful to you there. Again, in a considered written advice scenario, you can draw on the scenario you've got. You can also draw on all of those cases and all the learning that you did where you learnt about a whole lot of things that happened in the absence of the parties having agreed something else. So the example I gave you last week there was things like notices clauses. So if we have, we know that if the parties don't agree to the contrary, then if somebody sends a notice by post, then it's been deemed to be sent at the time it got put in the letterbox. That pretty much doesn't suit anybody, right? So notices clauses have evolved over time to say the parties agree that notices will be deemed to have been received the 3rd business day after posting, or the next business day after email, or if the email is received outside of business hours, then the next business day. So in the example we used last week was with a public holiday last week, if somebody sent a notice under a contract or sent an acceptance at 7 p.m. on Thursday night, it's quite, by email, it's quite reasonable that somebody wouldn't read it until 9 a.m. on Monday morning. Less and less reasonable these days, but I don't. I like to turn my email off. And you've got all that lost time in between where you've had no control over what's going on. But you might specify something different. So you can draw on what you know about contract law, and then because you have the luxury of a number of weeks to consider a problem and send out advice, something that doesn't happen in the real world, by the way, they'll actually be pushing you to answer them over the phone straight away. You can actually go to the precedent resources and look at that. You can't do that in an exam. You might actually, though, it wouldn't be a stupid thing to do to scribble down what you think it is that you would do and say, I would also be looking in these resources for this, or I would be, you know, that's fine too. We're looking to see if you think like a lawyer. So most of the time, the problems will run a kind of along this kind of trajectory. Not enough water in my system. Is there a contract? If there's no contract, usually we're done. If there is a contract, then the next question is, were there any formalities that needed to be complied with? So in formalities, when we're talking about things like Section 126 of the Instruments Act, but there might be formalities under other pieces of legislation too. I'm not expecting you to carry these around in your head. You might be asking the question though. So ones I can think of off the top of my head include if something was sold to somebody door to door, then there are provisions in the ACL that says there needs to be a written contract. So that's a formalities requirement. But we know about guarantees, we know about anything to do with land. We know that if somebody is going to be an agent to sign a guarantee or anything to do with land, that they have to be appointed in writing as well. So once we've got through that hurdle, if there is one, then we also need to think about, do all the parties have capacity? So have we got any children involved? Have we got people who are drunk or insane or under the influence of narcotics in some way? And then once we get through all of that process, then we start to think about what the terms of the contract are. So sometimes we can actually just pull these things out really quickly, just get rid of them really quickly, that we just know immediately. You might just make a quick assumption. There's nothing in this problem that suggests that anybody is under the age of 18. Or it doesn't appear that anybody's insane. If those assumptions are incorrect, then my answer might be. The other thing you have to remember, particularly with capacity, is capacity generally only makes a contract voidable by the person who is suffering the incapacity. It doesn't mean, just because you've got a minor involved in a contract, doesn't prevent the minor enforcing the contract. It just might mean you can't enforce the contract against the minor. So sometimes we might be plopping along straight into the terms much quicker otherwise. So, in working out whether we've got a contract, then we think about what the formation elements are. I know the people you sleep with know these now because you're muttering them in your sleep as you go. You understand what these are. So offer and acceptance is about asking whether or not the parties have reached consensus. And if they have, if we've done it with that traditional offer matched with an acceptance, has that been communicated? Was the acceptance a true acceptance, or was it potentially a counter-offer, intentionally or otherwise? The counter-offer, was it accepted or rejected? Do we actually have the formation of agreement? Consideration. This goes to really whether there is a bargain, whether there is a quid pro quo, whether there is an exchange of promises. Ultimately, and very much linked in with the idea of consideration, is this idea of intention. Much less problematic now since homogeneous than it used to be, but really we're just asking, did the parties intend that this agreement will have a legal consequence? Or was it just an honour arrangement? Was it just an understanding? For an agreement to be a legal agreement, that means that the parties expect or intend that they can sue and be sued on that agreement. So is that intention actually there? And then lastly, the certainty factor, which is the one that feeds into the contents later on. Have the parties clearly identified their rights and their responsibilities? Are the promises real promises, or is there a risk that they are illusory? Do we have clarity? Do we have completeness? And are they real promises? Of course, going back to offer and acceptance, sometimes we can't match that offer and acceptance. We just have a consensus ad idem. And so Brambles allows us to, or provides a test. So it asks us to look at, can agreement be inferred from the conduct of the parties? Then, has mutual assent manifested? Can we see that they are acting in relation to that arrangement? And would a reasonable person having that information assume that the parties had concluded a bargain? And if the answer to all of those is yes, then we can have an agreement, even if we can't easily match an offer and an acceptance. So, working through the issues in relation to agreement or offer and acceptance, the analysis often goes like this. Is there an offer? Again, we use an objective test. Carlyle and Carbolic Smoke Ball demonstrate that objective test. Toll and Alpha Farm help us get there as well. There are no shortage of precedents to demonstrate that requirement for an objective test. In thinking about whether there's an offer or not, sometimes we have to look at conduct that it might not be an offer. So we distinguish offers from puffs, invitations to treat, and supplies of information. In relation to auctions and tenders, I always feel like that's a bit of a red herring, but we have to cover it. An auction is not tricky at all. The person who is making bids at an auction makes an offer. The person who is selling things, who is receiving the bids, they can accept or reject the offer. They usually do that through an agent, who is the auctioneer. The auctioneer will then have instructions which will allow them to accept or reject. So the agreement is made at the point in time where the offer itself is accepted, which usually or often happens by the agent hitting the hammer. Bilateral and unilateral contracts. Sometimes we need to distinguish between the two types of contract. Very rarely. I see a lot of talk about bilateral contracts in assignments from time to time. The fact that a contract is bilateral is very rarely interesting. Unilateral contracts are a little bit more unique, and we sometimes need to point out that a contract will be unilateral because the thing that makes a unilateral contract unique or different from the vast majority of contracts is at the point in time when the contract is made, consideration has already been provided by the offeror. Sorry, the offeree. So one party has almost always at that point fulfilled their obligations because they have accepted the offer through their conduct. And so it's unilateral, not because there's one party, but because at that point in time only one party has an obligation. Once an offer is made, sometimes we need to think about whether that offer can be revoked or not. Can somebody give me an example of a scenario where an offer can't be revoked?
An option.
An option. So how do we know when we've got an option as opposed to just a promise to keep the offer open?
Because it's a separate contract.
Separate contract, so it needs consideration, it needs intention, it needs certainty, all of those things. Absolutely. Nice work. So once we get around to then the question, was any or all of those things might be in a problem, right? Probably not all of them, but you never know. Has the offer been accepted? So an agreement is made at the place and at the time that it is accepted. So acceptance is the sperm hitting the offer egg. So again, objective test. Complete silence is that, so if it's an offer is framed in such a way that says if I hear nothing more from you, I'll assume that we're all good to go? No. Okay, so we need some sort of objective indication. Do there have to be words or signatures? No. So it could be something as simple as handing money over, it could be a nod, a wink, a text message, an emoji, anything really. So we need to think about what constitutes acceptance. The major assignment last semester involved an exchange of text messages that included the thumbs up and thumbs down emojis at different points. And so people were required to think about that conduct and whether it was acceptance or not. You might need to think about how it's communicated. So again, if letters were sent, if emails were sent, if text messages were sent, what was the understanding of the parties about the ways that things could be communicated? And then lastly, we need to think about what happens if they don't correspond perfectly with each other. So again, that's back to that Brambles test. So you don't need to use Brambles if you've got an offer and a matching acceptance, or an offer and a counter offer and an acceptance, or an offer, a counter offer, another counter offer and a rejection. Doesn't matter. You've got a path you can follow. You really only need to go to Brambles when you have information that doesn't neatly mix together, and then think about what the parties did next and how they reacted in relation to that. Sometimes we need to distinguish offers from other things. I talked about that a second ago, so thinking about how offers are terminated. I've forgotten that. I told you I wasn't going to go through all these slides. I talked too much with the general slides. Revocation. So an offer can be rejected in a range of different ways. Basically, you can withdraw it. You can just say, you know, that offer I made, it's not on the table anymore. Provided that acceptance hasn't been communicated yet. A revocation itself is only affected when it's actually communicated. And a promise to hold an offer open, only binding if there's an option. Sometimes offers lapse. An offer will lapse if it's not accepted within a specified time or a reasonable time. So I could offer to sell you my Surface Pen here, which I've hacked to use as a PowerPoint slide mover. I can say, yep, I want $20 for it. Anytime over the next 5 days, you let me know. Day 6, I can just say no. I'm not interested anymore, I don't have to do anything. But if I want to withdraw the offer earlier than that, and I do, because I love this pen and I'm not selling it to anybody, so I need to withdraw. I need to specifically communicate my withdrawal of the offer. If one of the parties dies, the offer lapses. So offers are generally, sometimes, and usually in the case of unilateral offers, they're offers to the world, but an offer that is usually specific to one person, and it's made by one person. That could include a legal person, by the way. A company is a person as far as the law is concerned. But if one of them dies, or in the case of a company, goes into liquidation or is wound up, the offer disappears. So Fong and Chile is an exception to that, where the offeror died, but news of the offeror's death didn't reach the offeree until after they had accepted the offer. So if they had found out about the death before they had accepted, it would have been terminated. Yep.
Does a binding on successors clause, does that work?
Binding on,
In all cases?
not in all cases. So binding on a successor would suggest that we have an agreement in place, and that agreement contemplates the idea that somebody's estate or their transferee could take that on. If you and I had an agreement in relation to the supply of water, and I have a contract to supply water to you, and you then transfer the rights to that to Grace, because you can't transfer an obligation, you need to novate that, and I need to agree to continue to supply Grace. But yeah, so yes, but an offer, if I'm making an offer to you, there's no agreement yet, it's just an offer. Sorry, just took the opportunity to drink and then didn't. So failure of condition precedent too. So sometimes offers are conditional. I will offer to buy this house for $2 million subject to financing. So that offer might be accepted, but I then can still withdraw. There is no contract if I don't get my financing. Sometimes offers are rejected. Once an offer is rejected, it's off the table. A straight rejection, just I offer to sell you something, you say no, you come back the next day and say, actually, I've thought about it, I'd like to do that. Nothing to stop me from saying, okay, that's great. In fact, technically that would be you making me an offer on the terms that I made the offer to you today and me accepting them because the offer is rejected. But I can also just walk away and say, no, I'm not interested. You didn't want it yesterday, you can't have it today. A counter offer. So a change to the terms of the offer is a rejection of the original offer. So if I offer you something, you say, I'll do that, but you need to charge me $10 less. That is a counter offer. It's a rejection of the original offer. However, you need to be able to distinguish between a counter offer and a mere inquiry. So in Stevenson, Jacques and Co. and McLean, one of the many, many cases about buying horses from memory, asking questions about whether someone would consider or enter into a negotiation is an inquiry. That's different from actually offering a lower price or a different price. Conditions precedent. So these are external events which need to occur for the formation of a contract or before performance under an existing contract is required. So financing is a really good example there. Condition subsequent refers to an external event that will bring the contract to an end. So, for example, sometimes you need to have an agreement in place before you can go and seek a change to a license or something from a government authority. So a few years ago, I sold I didn't sell it, but I acted for a company that was selling its flying school. And in order to run a flying school, you need to have a number of licenses, licenses in relation to the light aircraft. You need to have somebody who's suitably qualified, a range of different things, but you can't actually apply for those licenses until you have a contract in place. So the contract needed to be structured on the basis that it would cease to have any effect for any of the parties if the condition subsequent, the getting of the licenses, wasn't approved. Acceptance. We need an offer. We need the offer to be accepted while it's still open, and we need the acceptance to be communicated. Pretty straightforward. We have offer, matching acceptance, we have agreement. Okay, actually, before I go into consideration, any other questions about agreement? So, this comes straight from the slide pack, by the way. This is the sort of mind map or the flow chart for consideration. So there are two fundamental questions that you need to ask yourself in relation to consideration. Firstly, does it meet this benefit detriment requirement, the Curry and Meese test? Can we see that each party gives something in exchange for getting something? And then the second part of the test is the bargain requirement. Is the thing that you give and the thing that you get in exchange for each other in some way? Are they related to this deal? So in relation to benefit and detriment, we need to look at the promises that are made. Do they confer a benefit, and do they give rise to a legal detriment? Because a consideration needs to be legally sufficient. It doesn't need to be adequate. So there doesn't need to be an exchange of things of equal value. There just needs to be a legal detriment from each side. We have a range then of exceptions to these rules. And most of them we need to explore over and over again. So consideration needs to move from the promisee. So the person who is receiving a benefit of a promise under a contract needs to give something in exchange for that promise that they're receiving under the contract. So consideration is the price for the promise. It is almost always another promise. It's almost always corresponding promises. But in theory, you can promise me something. So an offer is made that includes you promising to put a circus tent up in my backyard. And that one's for you, Isabel, wherever you are. I want a Spiegel tent in my backyard, and I need to pay consideration for that. But I might, at your direction, not actually pay that to Isabel for her Spiegel tent. I don't know if it's actually your Spiegel tent, Isabel, but to send it off and pay that money to a charity, for example, or something. I need some detriment. They don't have to exchange both ways. Well, it has to go both ways, but it doesn't have to go from the promisee to the promisor. Another exception is that part payment of a debt will not be good consideration for a promise to waive or reduce the debt. So an existing legal duty, meeting an existing legal duty will not necessarily be, or part of an existing legal duty will not necessarily be good consideration for a promise to change the deal. You need fresh consideration for a new arrangement. Consideration needs to be adequate, but not, it needs to be sufficient, doesn't need to be adequate. We've spoken about that. Past consideration isn't good consideration. Things you've done in the past don't meet that bargain requirement. They're not in exchange for each other. And the performance of an existing legal duty will also not be good consideration. Intention. Intention is much less worrisome these days than it was when I went to uni. As a general rule, we need to see a voluntary assumption of a legally enforceable duty in order for a legally enforceable contract. So intention is tied up in this idea of consideration. that if we're going to get the benefit of a private law that only applies to the parties to this contract, then we need to see that you have paid something for that and that that is in fact what you intended. We tend to, in a written agreement, there will usually be an express statement. The parties intend for this to be binding. They intend for this to be their entire agreement quite often. Sometimes there will be an express statement that the parties don't intend for it to be binding, that this is going to be an arrangement in honour only. Again, the rules are pretty much the same anyway. The question is one of onus here. So the category of contract, whether it's a social and domestic relationship or a commercial relationship, doesn't get us very far anymore. It's just really goes to the onus of who needs to prove what. If it's a commercial arrangement and a party is seeking to say this was in honour only, then that is the party who has the onus of demonstrating that there was no intention. But the court will look at the documents and they will look at what the conduct of the parties were leading up to the advance being made or whatever it is that the subject matter of this contract is. And you'll remember we had very different outcomes in the MMC case as opposed to the ANI case. The effect, probably what's the most interesting, well, I think it's interesting anyway, the most interesting area coming out of the intention stuff is looking at preliminary agreements, looking at what the status of promises that were made in the lead up to the parties having a final agreement or not. That can be the most tricky to unpick and to think through. So I suspect that many of you have been thinking about Masters and Cameron fairly recently, so you will have some understanding about how that works. Difficult issues can arise in relation to honour clauses, letters of comfort, sometimes agreement with government. Intention, it can be particularly fraught with government contracts. When we think about Papua New Guinea and Lae, it was a territory of Papua New Guinea and Lae, something like that. And when we think about woolen mills as well, there are some constitutional and other issues there about whether or not there is capacity, but tend to go, in relation to contracts with government, you really need very explicit statements that the government in fact intended to be bound as well as have the capacity to be bound. But where I see it all the time is preliminary agreements. Confidentiality agreements, heads of terms, letters of intent, exchanges of emails about what an agreement might look like later. At what point do we have an agreement when the parties agree, verb, or when the document is written down? And Masters and Cameron walks us through the test for that. Woolworths and Kelly I've mentioned a couple of times because it has come up in the critical analysis piece a number of times as well. That is Justice Kirby's analysis of why consideration needs to be sufficient but doesn't need to be adequate. Chappell and Nestle is the other case that is on point here, but Woolworths clearly the Australian case, and subsequent to Chappell reinforces Chappell, so it's a good case. Shahid and the Australasian College of Dermatologists is one of my favourite cases as well. It's a really good outline of the things that the court will take into account in determining whether intention can be found or not. And so it creates a good test for you. So it looks at, is there documentation? Is there an arm's length relationship? And were there payments made in particular? What was the nature of the relationship? And it doesn't, again, objective test, it doesn't matter what the Australasian College of Dermatologists intended when it set out a set of detailed rules and took a lady's money. What matters is what a reasonable person having access to that same information would have believed that they intended by that conduct. Woolen Mills is a case many of you love to hate. and we get caught up on it sometimes. We haven't been too caught up on it this time though. 4 factors that demonstrate the absence of intention. So again, we do this sometimes, or quite often actually in the law, is we work out what something is by really understanding what it's not. And so the options here in relation to government included that they didn't actually have the capacity to enter into a contract, that the person who made the announcement of a policy had no authority to make that. They had no bargain, so there was no commercial interest in the purchase of the wool, and that it was potentially an illusory promise anyway. The Commonwealth had reserved its right to vary the subsidy at any time. Presumptions, you're on top of presumptions, aren't you, with Erma? It really just goes to onus. So lots and lots of statements about all those old cases where there is love is so rare in these cold courts, or whatever it is that Justice Aitken said. It's all pretty much academic now. We go straight to the Erma test, and then if we want to raise those arguments, we might use merit and merit in some of those other cases to reinforce them, but it really just goes to onus as the key issue here. Certainty. Are you thinking, why did I bother coming to class all of those weeks? We could have just done everything in one slide set, and it's not even the only slide pack for the day. Because so am I. I just might just do this first class next semester and then show up and hope people take me to the pub at the end. What do you reckon? So, certainty, there are 3 aspects to certainty. Okay? If we just if we start with thinking about, is the contract sufficiently complete and is it clear, then the third rung of certainty is about, is it a real promise or are they illusory promises? So we end up with that double negative language of not illusory. But not illusory is kind of, that's the easy one to see in a way, where the party who is making promises has such broad discretion, just like the Commonwealth did in in Australian Woolen Mills, they can vary the price at any time. They can do what they want to do at any time. It's likely to be an illusory promise. So clarity, so the question of completeness goes to, are the essential terms there? Now this is something that you will see from time to time in these exam scenarios, particularly if you're being asked to work out what might you put in a contract. So identifying from the scenario what's likely to be essential, they're the key terms. You know, you're never going to be asked to write a term, you're just going to be asked to identify what kind of term needs to be put in there. So for example, if the scenario talks about a party wanting to sell their house and somebody else wanting to buy it, it's likely to be an essential term what the house is, that it's being sold, that there'll be new ownership as opposed to it being rented or something different, and what the price is. And other terms about whether or not repairs need to be made are likely to be warranties. We can't have an agreement to agree. Okay? We can have an agreement, we can have an option, which gives somebody a right to create a new contract at a particular price or a particular way of calculating a price, but a term that says at the end of the lease we'll just get in a room and we'll agree what to do next, it's not sufficiently certain. Terms that are vague or ambiguous, we've got to think about whether the term makes sense. Now remember, the overarching rule here is that the courts would rather find a contract if it looks like a contract and appears that there is an intention for there to be a contract than to come up with something, they're no contract. So they will find a sensible reading if they can. But if they can't find a sensible reading, if it doesn't make sense, then they won't do that. And then the next question becomes, well, if it's not sensible, if it's illusory, or if it's just unclear, can the rest of the contract operate without it, or does the whole contract fall aside? In relation to illusory in particular, but not only, if a ailing term only impacts one party, so if one party has the discretion or one party has a right but it's vague and ill-expressed, and that party is prepared to waive that right or waive that illusory promise right that they have, and the contract can continue on, then we don't have any issue at all. So you can't get out of a contract on the basis that the other person has some sort of illusory right that they're prepared to waive. Spoken about this already. Essential terms, there isn't a one-size-fits-all, but generally who the parties are is almost always an essential term. Very occasionally in a unilateral contract, or perhaps in a deed where somebody is making a bequest or a gift of some sort, there might be a class of potential beneficiaries, not necessarily, you might not know who all of them are. You might have a contract with a company that in relation to, that waives or includes an exclusion clause for the benefit of employees, and those employees might be changing all the time, but the contracting party itself doesn't. The subject matter of the contract, like what the contract's about, who's doing what, that's almost always essential. Price, or some sort of effective mechanism or formula for determining what a price is, not always, but almost always an essential term. And if you've got a contract that isn't just wholly executed in one transaction, is going over a period of time, it is quite usual that the periods of time will also be essential. But again, you need to think about that for each contract that you're looking at, and you might find that one of the things that you're doing, if you're thinking about it, if you're trying to write a contract for your client and you know what really matters to your client, then you might be seeking to make that thing that really matters to your client an essential term, and articulating it as that rather than waiting for the courts to work it out for themselves. So, formalities. Remember, contract or agreement is a verb. It is actually also a noun, despite the fact that my slide says that it's not. But when we're talking about a contract or an agreement in the sense of a legally binding agreement, we are talking about the verb, the things that our clients do. They're reaching an agreement. The noun, the contract document or the agreement document, that its job is usually to record that arrangement. Now, when an agreement is formed on the parties signing a document that articulates their agreement, then it represents the agreement, absolutely, but it's never going to incorporate every potential thing that can happen. Unless a statute of fraud successor legislation says that some kind of formal document is required, there is nothing in the common law that says that you need to have a document in order to create an agreement. Statute of frauds, I think we've I really must update that amount. So in Victoria, and we're largely dealing with Victorian law, pretty much all of these, other than contracts made in consideration of marriage and contracts not to be performed within the space of 1 year. Actually, no, you're right, sorry. You might not be right, I'm right now. There are 5 things on that list and only 2 of them are continuing. Contracts of guarantee, contracts that are for the sale of an interest in land, they are required to be in writing under Victorian law. The others no longer so. My memory is that in Tasmania, technically all of those still need to be in writing. But varies from state to state. I did get a question during the week about whether you would need to have an understanding of how they were different in every state, and the short answer to that is probably not. I can't imagine why you would, but if you were to, it would not be anything more than being able to identify that you need to check at the state level, and you can assume, unless it specifically says differently, that it's Victorian law. There was a question in one of them once which talked about a verbal guarantee, and the question included would the answer be different if the facts happened in New South Wales, because you can't have a verbal guarantee in Victoria, but you can in New South Wales. But there was enough information in the question to point people in the right direction for that one, from memory anyway. We talked about this relatively recently. The trick in relation to formalities is what satisfies the requirement for formalities, particularly if you don't have an agreement but you have a memorandum or note of the agreement. So a written document that forms the agreement clearly needs to be written prior to the agreement being made, and the act of signing it creates the agreement. But if we have a memorandum or note of agreement, the parties have reached agreement, and then their agreement is recorded subsequently. Signature isn't really a big issue. We have this authenticated signature fiction idea that as long as we've got some sort of mark or some sort of knowledge that a person has read and understood the terms, that's the focus point of agreement. Though I was interested to see in that news article that I brought to your attention last week that at least 2 of the people who had signed those standard form contracts in relation to telephone contracts couldn't actually sign their names, so they couldn't write. And one would think that if you can't write, then there's a very high chance you can't read either. Maybe not, but very high chance. So we end up in this odd position. Well, if you then we end up with a different kind of capacity question. These days we don't have any issues in particular around electronic transactions either. So just because you haven't physically signed a document doesn't mean that it can't be deemed to be signed under the Act. Although for some reason they won't pay me unless I print out or scan a PDF with my signature on it here. Even though we teach this stuff. What do you do? Capacity, again, not an element of formation. When we've talked about it, we have focused on young people in particular. That's where a lot of the cases are, but it is worth remembering that there are larger categories than just people under the age of 18. So, oh, sorry, this is just a slide reminding you it's not a formation element, so go and answer the formation elements first before you get yourself too caught up in the capacity issue. I could take that one out and I'd get down to 41 slides, wouldn't I? Categories of people where capacity might be raised as an issue include minors, the mentally ill and intoxicated. I don't know that it's fair to bundle them, but otherwise the print gets too small. Corporations, there's no real question about whether a corporation can enter into a contract or not. Corporations have capacity to enter into a contract or not. The real question there tends to, and you don't need to know this particularly for this subject, you will come across it in company law, it's a question of authority. Who has the authority to sign for the company? What can outsiders to the company assume is a proper signature by the company? And there's also, can a company enter into contracts in the pre-incorporation stage? I promise you there is nothing on the exam about any of those things. Bankrupts can still enter into contracts. They just might have limits on the amounts, but there are searches that you can do to deal with that. Unincorporated associations, so clubs, for example, sporting clubs or your local park run volunteer organisation or whatever it is, or partnerships including law firms and accounting firms well, now they can incorporate it, but 20 years ago, they didn't have legal status, right? Partnerships are not, they don't have capacity to contract. They are not separate legal entities. So generally, when a partnership, quote unquote, enters into a contract, I say quote unquote because it can't, an individual partner will enter into a contract for the benefit of themselves and each of their other partners. And the Partnership Act then says all of the partners will be jointly and severally liable for all of the debts of all of the other partners. So, you know, some people think hard about getting married. You should think much harder about getting into a partnership, because it's much easier to separate out your assets from your spouse than it is from your partners.
Kath, just a quick question.
Yep.
Sorry to digress, but that obviously changed, you said, because that was 20 years ago.
It's still there. There are still plenty of, well, I'm a sole practitioner and unincorporated. Up until over the last 20 years, there's been a fundamental change in the way that the professions are regulated. And I can't tell you exactly when the change was. It was probably less than 15 years ago, though, that lawyers could start practicing in an incorporated practice. So the idea was that because of the nature of the work that you're doing and the importance and the impact that it can have on your clients, that you shouldn't be able to limit your liability, which is effectively what a company is for. So that's why there are lots of very poor lawyers like me. Like my name is not on the title to my house. I don't have any assets at all. I guarantee debt all over the place, but I literally have no assets. And I think they suddenly worked out, well, that's kind of ridiculous, isn't it? Because everybody's structuring themselves to make sure that they that they have no assets. We may as well actually structure properly and limit liability in an appropriate way, because you would never advise your clients to go into business in a partnership unless they had to. You would always find a better structure to put them in. So barristers, on the other hand, they still can't incorporate and they can't go into partnership either. Barristers need to be sole practitioners. The stuff that's highlighted there, they're the only things that you're likely to see on the exam in relation to capacity. So minors, the mentally ill and intoxicated people. Technically, in some places, enemy aliens can't enter into a contract. It's only actually relevant if we're at war. I suspect that if you're on Nauru, you can't either, but that's not Australian law, so we're okay. But yeah, there are some technical other ones, but on the exam, the concepts, if you see them at all, will only relate to those. So, the overview in relation to minors, I don't intend to go all the way through this because we're down to the last hour and I want to do some problems. Basically, what's important here to remember is that if there is a capacity problem, it means that the person who has the capacity, the incapacity, disability, can avoid the contract. So it's not that you can just get out of a contract because the other party is a minor or was drunk or otherwise. And it's not all contracts. So if a contract that is for necessaries or a beneficial contract of employment will still be binding on the minor. There's no issue there. If the subject matter of the contract is of a permanent and continuous nature, so it relates to the sale of land or the sale of shares or something that has this ongoing nature, then it's binding unless it's repudiated by the minor or by the person suffering the incapacity. Victoria, slightly different. It's you can't actually ratify. later, but otherwise, anything else, it's only binding if it's ratified. Oh, sorry, that's trying to highlight and it's not. Privity. Pretty straightforward. This is why who the parties are is going to be an essential term each time, because only the parties to the contract can sue or be sued on that contract. So no burden can be imposed on a party who's not a party, a person who is not a party, and no benefit can be conferred on a person who is not a party. Gets tricky when we're looking at things like insurance, or where we have steps in a process like stevedoring where only one person can do something. Most of the chapter on privity is about whether it's actually relevant in this century anymore, and whether law reform should see us get rid of the idea of privity of contract. That's why it tends to show up in the critical analysis questions. There are a number of ways that the privity rule can be circumvented. They include holding rights for a party on trust. Often this is how capacity issues disappear as well, that instead of having a contract with the minor, you will contract or insist on a contract with a parent or guardian who holds the rights on trust for the beneficiary, for the child. Beneficiaries might be entitled to assert an estoppel against the promisor, particularly if promises were made about things being done in a particular way. The fact that they're not parties might still allow them to claim an estoppel. Misleading and deceptive conduct. Remember Section 18 of the ACL. Making promises that you will act in a certain way, and misleading or potentially deceiving the person who is not a party to the contract might have consequences. And also tort might be an avenue for you. Again, I'm not going to be asking you a question in this exam that requires you to give me a lengthy description of tort in any way. But I'll tell you what, Tina will love it if you do, I'm sure. So, list of exceptions. Agency is probably the one that we spoke about the most. The three-party collateral contracts are a little bit tricky. It's worth thinking a little bit about those. And assignments or novations, remembering that you cannot transfer an obligation to somebody else. Okay? You can transfer or assign a right, but you cannot transfer an obligation. All right, trying to get it all onto one little slide. This is the stuff that we covered in the last 3 weeks. So once we worked out what a contract was, then we started to talk about how we work out what the terms of the contract are. We did that by breaking them up into express terms and implied terms, and then we talked about the extent to which there might be any gaps and how the courts will fill those gaps. And we used disclaimers and limiting terms as a kind of proxy for talking through all of those issues, because they're the kinds of terms that we're often trying to get rid of. So, express terms, largely problems around this area are asking the question, when does a statement that's made during a negotiation become an actual term or an express term of the contract? We look at the language used. So J.J. Savage, you'll remember there was an estimate for the speed that the boat would go. Oscar Chess and Williams, Lord Justice Denning's discussion there about what a person we could imagine what he would say if he was challenged to promise that it was a 1948 Morris. He would say, oh, I don't know anything more than you, you're the expert. Relative expertise. Again, who is the one who is in the best position to know what the end result is? How important it was. So Van den Eschert, the statement was made right at the point of time where the contract was about to be signed. Oh, I didn't go and get a test for white ants. Oh, don't worry about it. If there were white ants, I would have done something about them. Now, if that statement had been made 3 weeks before, it would have been perfectly reasonable to expect the vendor to make their own inquiries. But as they were made within minutes of the contract being signed, their importance in the decision to sign the contract was relevant. Timing, again, Van den Eschet and Chapel. The extent to which there is a written agreement. A subsequent written agreement that is signed trumps an earlier oral negotiation. And other relevant factors. Annoying, but it's there, so you don't have to be limited. Implied terms. We've got a number of different ways that we find them. We've got terms at law, we've got terms in fact. Look, I'll get to that in just a second, but there are some consistent rules. So if we're going to imply a term into a contract, it needs to be consistent. It cannot contradict an express term. Conversely, if a term is going to be implied by a statute and that statute says that you can't contract out of it, then any terms, express terms that you have that seek to do that will be void. We talked about the relationship that they have, that implied terms have with entire agreement clauses. And I used the case study of Nifsan and Busky in relation to that. So it's worth noting that an implied term, a statutory implied term in particular, won't necessarily be defeated by an entire agreement clause. Sometimes the law will require them, and sometimes they won't be capable of exclusion. If you have implied terms, you are effectively arguing that the contract that you have is a combination of the express terms and these additional implied terms. So if you have a written document that has the express terms, the parole evidence rule doesn't apply because your entire agreement is not in writing. You need to mount an argument, though, that the entire agreement is the written terms plus these implied terms. These implied terms aren't inconsistent, that they're implied by law or by fact or otherwise. And so there's no impediment under the parole evidence rule. Mind you, the person who's seeking to keep it out will say that that is intended to be the entire agreement and the parole evidence rule should be listened to. So you need to have some good arguments. Terms implied in fact. So BP for refinery is the Australian codification, for want of a better word, of a very ancient decision in the Moorcock. So terms implied in fact need to be reasonable and equitable. They need to be necessary in order to give business efficacy to the arrangement. They need to be so obvious that it goes without saying. They need to be able to be expressed clearly, and they need to be consistent with, or they cannot contradict, the express terms. Terms that are implied as a matter of law need to be applicable to a definable class of a contractual relationship. So they come up, so there's a number of implied terms that relate to the sale of goods, for example, merchantable quality, fitness for purpose. These tend to be codified now in, so the Sale of Goods Act, for example, but a number of them have arisen over time and they will be implied by law if the parties haven't agreed something different. So again, they need to be consistent with the terms that the parties have agreed. So they need to be applicable to that kind of relationship and necessary. So again, partnership. A partnership is formed when the Partnership Act, just if you want to know, says that you're acting in concert with a view to making a profit. Most partners will want to enter into an agreement. there will be an implied term in partnership agreements that partners will act in good faith towards each other and the partnership assets, because partners are liable for the debts of each of the other partners. So there's a big obligation that comes with it. So that comes out of the relationship. A trustee-beneficiary relationship includes bona fides and a duty of utmost good faith. So terms that are applied in law as opposed to fact, you might need to compare how they're different or how they're similar, how they work together. Basically, if you're trying to imply a term into a contract or argue that a term should be implied, you can run the at law, in fact, arguments at the same time. It's not necessarily one or the other. And then we've got terms implied by custom. Again, the custom itself needs to be notorious. It needs to be consistent with the rest of the contract. Even though it's notorious, you don't actually have to have actual knowledge, which can be a little bit difficult. Particularly given the case that we used, Constant, it was found that there wasn't this notorious promise that brokers would make these payments. And it's just a question of fact as to what's happening in that industry. In order for a term to be implied, the following conditions must be fulfilled. So I've tried to amalgamate on the one slide all of the different conditions. So the term itself needs to be reasonable and equitable. It needs to be necessary to give business efficacy. It needs to be so obvious that it goes without saying. It needs to be capable of a clear expression, and it needs to be consistent with the rest of the contract. They can overlap, these ideas of necessary to give business efficacy and so obvious it goes without saying. If the agreement appears to be wholly in writing, then the test will be applied much more strictly than if it's clearly a verbal agreement. And if the agreement isn't complete on its face, the test is whether a particular term is necessary for the reasonable or effective operation of the contract. Sorry, we're running really late. I'm close to the end now, but if you need to have a break, you probably need to wove me down. I can feel from my throat how I'm going over time. Exclusion terms. So we're at topic 11 now, and that was our last topic of any content. Exclusion clauses, it's pretty straightforward. If there is an exclusion clause, the first thing you want to ask yourself is, does the statute apply? And if it does, go straight to the statute. Do not worry about the common law. If it doesn't, then we've got to go and have a look at the common law test. So, common law approach is effectively, is the clause, so this exclusion clause or the limiting clause, is it incorporated as part of the contract? So again, the cases that we looked at included things like cases involving dry cleaners, where there was information on the back of a ticket, where there was information on a sign, working out whether or not this limitation clause is part of the contract or not requires us to go back to those express terms. Secondly, is the person who's seeking to get the benefit of this exclusion clause privy to the contract? So is it drafted in such a way where it also protects agents or employees, and is it effectively drafted in that way? And if the answer to both of those is yes, then the clause applies to the issue that's in dispute. So with exclusion clauses, this is the framework that we discussed for working through them. Legislation. If it's a legislation applies, we go straight to the legislation. Is it properly incorporated? Is there privity? Does the clause, properly as a matter of construction, actually reduce or exclude the liability in relation to the subject matter? Yes, sorry, little. So the key issue is the last one each time. So that requires you to do some construction of the contract. Contract itself might be unenforceable, but there are a couple of things that will still be worth looking at if that applies, so just generally. is there some sort of reliance? So think of cases like Beaton and McDivitt, for example. Has there been some part performance? We didn't really talk about, and you will not need in the exam, restitution. We did talk about severance in a range of different areas. But in relation to severance, again, the same principles apply each time around. Can this clause be taken out of the contract? And if it can the rest of it operate? If it can't, what do we do about that? If there is no impact of, if there is no statutory impact, you might still need to look at whether there is an estoppel or something that prevents that, that limiting clause being applied. Oops, sorry, going the wrong way. 2 more slides, I think. Constructive trust. I thought I'd put a slide in there because we keep sort of skirting around estoppel. There is a chapter in your textbook which is quite useful on estoppel, which you might find useful to read. But really, for the purposes of this subject, what you need to understand is just what an estoppel is. The word itself comes from a French word, which I'm not going to try and pronounce, which actually means to stop, put a plug in it, effectively, to put a rag or something in a hole. And so, effectively, what an estoppel does is it stops or prevents a person from claiming a legal right because of something that they have done that would make it unfair. Now, those of you who are lovers will be doing your best to write contracts that mean you never have to rely on this, but the fighters will be looking for estoppels left, right and centre to see what you can do to help your client. So an equitable estoppel can also arise when a plaintiff has acted to their detriment on the faith of an expectation. So if somebody has, and Beaton and McDivitt is a good example of this, where there was no proper agreement, there was nothing in writing, but somebody has gone onto the land, they have done permaculture, whatever that meant in 1970 something, they've spent some money, they've put their time and effort into something based on a promise that they understood would be binding. It turned out there was no contract, but there was an estoppel that prevented that claim of no contract. I think this is the last one. It is worth going into the exam having a couple of different ways of classifying the different things that you're looking at. So it can be useful when you're solving problems to try and match things into like categories or groups of categories so that you can distinguish and apply the rules. So unilateral and bilateral is probably the least interesting of them. Thinking about the type of term, is it essential? Is it a warranty? Is it intermediate? Thinking about the enforceability of the clause or the contract itself. Unenforceable, void, voidable, severable. And then also the categorisation of statements or representations that are made. Which ones are promissory and which ones aren't. Those techniques and that language of classification will help you explain your answer and your thinking and bring you to the next level. Thought so? That's all I had. So it was actually technically 42 slides. Questions, concerns, frustrations?